Good evening, class. My name is Andrea, and I'm going to be talking to you about plea bargains, the process of them, and my stance on them. First, we'll start off with what a plea bargain is. What is a plea bargain? In order to understand the process of a plea bargain, we must first discuss what a plea bargain is. In basic terms, a plea bargain is a negotiated agreement, Due Process TV 2012, between the government and the defendant, and it gives both parties a relatively just result, Due Process TV 2012. The Bill of Rights entails some of our most fundamental liberties, 1, 2007. This includes the Sixth Amendment, which is our right to a jury of our peers. So where does a plea bargain come into play in all of this? Although a right to a jury amongst our peers is a right given to us, not all defendants reach this opportunity in the court process. According to the Bureau of Justice Statistics, 90 to 95% of both federal and state cases are resolved through the plea bargaining process, Devers 2011. In essence, plea bargains were created to assist the courts, as the government can focus more of their time and efforts in a jury case with more serious crimes. Without the plea deal, the system would simply grind to a halt. Due Process TV 2012. This is because the system cannot handle taking every case to a trial. If every case went to a trial with the resources we have now, it would create a backlog, Due Process TV 2012. List the elements of a valid plea bargain. The validity of a plea bargain is dependent upon three essential components: knowing waiver of rights, voluntary waiver, and the factual basis to support the charges to which the defendant is pleading guilty, Fine Law 2019. In terms of negotiation, a plea bargain involves three areas: charge bargaining, sentence bargaining, and fact bargaining. The most common type of plea bargaining is charge bargaining. It involves a negotiation of the specific criminal charges or counts that the defendant will face at trial. Usually, in return for a plea of guilty to a lesser charge, a prosecutor will dismiss the higher or other charges or counts, Fine Law 2019. The next type of plea bargaining is sentence bargaining. This involves the agreement to pleading guilty for the stated charge rather than a reduced charge, in return for a lighter sentence, Fine Law 2019. The last type of plea bargain is one that is not commonly used, and out of the other two types, it is the least used amongst both of them. This is fact bargaining. Fact bargaining involves an admission to certain facts, stipulating to the truth and existence of provable facts, thereby eliminating the need for the prosecutor to have to prove them, in return for an agreement not to introduce certain other facts into evidence, Fine Law 2019. Define the role of a judge in the plea bargaining process. Since the prosecution brings upon a plea bargain, this is a matter to be handled with them. Judges aren't involved except in very rare circumstances. Plea bargains that are accepted by the judge are then placed on the record in an open court, Fine Law 2019. There are jurisdictions in which the prosecution and the defense can work with the judge in order to determine what type of sentencing should the defendant receive in the event that a defendant accepts a plea bargain. Legal Information Institute, note date. The last part of this assignment is to create and provide an opinion on whether plea bargaining is a benefit to the United States criminal justice system and why. And based on my opinion, if I am going against plea bargaining, which I am, address arguments for its continued prevalence. Does the plea bargain process promote justice or impede it? Due Process TV 2012. The opinion on whether plea bargaining is a benefit to the United States criminal justice system can be seen as a benefit that can teeter back and forth for both the prosecution and the defense, depending on the case. The stance I am taking is that the plea bargaining system impedes justice rather than promoting it. Allowing plea bargains gives the defendant an opportunity to avoid his responsibility for his actions in relation to the crime he has committed. In the instances where the defendant did not commit the crime, a plea bargain creates charges of guilt in which he should have to admit to in order to avoid jail time. In a perfect court system where resources were abundant, the opportunity to allow a person his Sixth Amendment right, the right to a jury amongst his peers, to confront adverse witnesses, and to compulsory process for obtaining favorable witnesses, 2007. This also allows for both the prosecution and the defense to do their due diligence in presenting all the facts to the case. Arguments against my stance and for the continued use of this process vary for both the defense and the prosecution. For the prosecution, a plea bargain can be beneficial in more ways than one. For instance, with a plea bargain, the government is able to reserve its limited resources for more serious cases and aid in not creating a backlog of cases if ever case went to court. Another benefit to the prosecution is the opportunity to guarantee a punishment to the defendant, even if it may be a lesser one. Also, a plea bargain route can be beneficial if the prosecution is trying to obtain more information on a matter, such as a bigger person in the scheme of a crime or the inner workings of an illegal matter. On the defense side, a plea bargain can create an opportunity for a defendant to receive less of a punishment than if he were to be tried in court. Overall, there's a division on the stance of whether plea bargains are beneficial to our court system. In closing, with my opinion that plea bargains impede justice rather than promote it, Justice Brennan stated, "The framers did not intend to create rights. Rather, they designed the Bill of Rights to prohibit our government from infringing rights and liberties presumed to be pre-existing." 2007. The government initiates the process of a plea bargain. This is their deal, based on what benefits them the most.